Next week, where we are focusing more on the bankruptcy litigation issues and trends, we'll be focused more on various types of litigation issues, including, from my perspective, some of the safe harbor issues, set off, valuation, et cetera, preference. And so hopefully you'll be able to join us for that. It really, we're glad we had the opportunity to reach out to you and talk to you, and hope everyone stays safe and socially distant. Joe, do you want to wrap it up? I'm the head of the trading and marketing team here at Womble. I'm essentially an energy trading and commodities lawyer and a partner with Womble Bond in Houston. We also have Joe Tyrone, who is a partner and, as was mentioned, the co-head of our energy group globally. He resides in Baltimore, as well as makes more than the occasional trip here to Houston. He was integral in helping establish our Houston office here. We also have one of my partners from Delaware, who is a bankruptcy specialist, Evan Mangan, and he'll be talking on some of the bankruptcy, sort of the traditional bankruptcy issues. And finally, here in the Houston office, joining me is Jasper Mason, who is counsel with us, and he does a great deal of work with our upstream E&P clients. Okay, today we're going to talk about various things. I should mention that in addition to today's presentation, we have scheduled one for next week, which will take a little bit of a greater look at the litigation-related issues and sort of post-bankruptcy filing issues. So if you think of it as in two parts, this one mostly focuses on the pre-bankruptcy and then right into bankruptcy, and next week's will focus on after the filing and into the litigation and what you can expect. I think it's useful to maybe talk a little bit about what got us here. I think it's pretty obvious, but we'll talk a bit about that. We'll talk about some things that keep in mind on the upstream sector, both from a upstream E&P company perspective, as well as a little bit from a lending perspective. We'll talk about reserve-based lending, and then more the decline into bankruptcy and what happens when inevitably a counterparty does file for bankruptcy. How did we get here? This chart sort of shows a little bit of a long-term pricing on the WTI, but let's see if instead you were to look at some of the more recent pricing from, say, the beginning of January to now, which would be the tail end of this chart, you'll see a significant decrease. And if we were focused on just that section, you'd see a precipitous fall from, say, something approaching $60 a barrel for WTI crude spot prices down to about just over 20. And while we see a somewhat similar decline in NYMEX Henry Hub spot pricing, it's not quite as extreme, but you still see a relatively significant decrease, say from about a little over $2 down to about $1.65. Again, if you look at the sort of 2020 line and just a little bit beyond that, you can see that decline. Of course, high correlation between crude and natural gas prices. So, we've seen that commodity prices themselves fall pretty significantly in a short period of time. And as I think everyone has been paying attention knows, it's sort of not just the COVID issue. In addition to the pandemic, which has brought lots of businesses and our lives to a bit of a halt, which has led to about a 30% decrease in world demand for crude oil, which is huge. Also then, with a failure between some folks in Russia and the folks in Saudi Arabia to agree on production cuts, that really has led to significant price declines that we mentioned in the prior slides. In response, you have companies that are sort of scaling back their CapEx programs. We've seen a number of companies that have significantly downward project their CapEx, ending stock buybacks, some eliminating dividends, and of course, tragically too, we've seen a lot of staff reductions and furloughs. So given that kind of a economic background and environment, many in the industry see that we may be in a sort of time where we'll start seeing significant number of bankruptcies in the energy sector. With that as a sort of an overview and background and context, I'd like to turn it over to my colleague Jasper. We'll talk a little bit about specifically the upstream sector and some of the things that folks will want to do to protect themselves prior to any such bankruptcy.
Paul, thank you very much for that introduction. Good morning, everyone. Thanks for joining us here. Thanks again for your patience to work through our tech issues. And Paul, I have to say, as much as I would like to disagree with you, I'm afraid that I just can't. I do think that your last bullet there on the slide presented is unfortunately going to be viewed as somewhat prescient in the near future. There probably are numerous bankruptcies coming on the horizon. And therefore, I thought I'd take my part of the presentation this morning, restricting my comments mostly to upstream issues, and discuss the sort of pitfalls that I see companies fall into in failure to protect themselves from the exposure of counterparty risk or the insolvency or bankruptcy filing of companies that you've chosen to co-venture with or to contract with throughout the oil patch. So. Okay, so first of all, one of the easiest things to do, but yet, paradoxically, one of the things that's overlooked more often than many other things we see is the failure to properly record instruments that will protect you in terms of your relationship with these counterparties who are potentially insolvent or on the cusp of bankruptcy. Recording laws, as in Texas and in most other states, they exist to protect good faith purchasers and creditors. Purchasers to make sure that obviously that you're taking good title to the asset that you're purchasing and that no other competing claims are out there, or if they are, that you have the more compelling argument. But creditors also, because you want to make sure that any other parties that have, for example, lent money to the potentially insolvent party haven't recorded ahead of you, perfected their security interest ahead of you. And even though you may have lent the money or performed the work or engaged in the relationship before on the calendar, these other parties came to the situation, you may find yourself, due to the priority laws in the bankruptcy code, further down the trough if time were to come where a party needed to make distributions and pay all of the debts that it's owed. You'll find that you're sometimes, as they say, out of the money. And whereas if you had perfected your security interest timely, especially by recording, that you'd be able to do so in a way that protects yourself. So again, it's a simple thing, but we'll go through some of the basics because as we turn into the environment that Paul was discussing a minute ago and that Joe and Kevin will discuss in greater detail, you want to make sure that you're set up for the rainy day or the worst case scenario, and making sure that in a situation where an asset may be auctioned or sold for pennies on the dollar, that the pennies that the party does get go to you if necessary. So the first step, of course, is to record that instrument properly, is to record it in the county where the obligation exists, where the real property exists, in order to protect yourself. And to make sure that all of your, once again, that you're at the correct place in line should you come to a situation where an asset needs to be sold or a company needs to be liquidated and the creditors or co-venturers need to be compensated. Not only do you want to record in the proper county to make sure that everyone who would either lend money in or purchase properties from a party located in that county, you want to make sure that the instrument itself is eligible for recording. A lot of the comments that I'll go through as we go through the rest of the slides are concerning joint operating agreements, for example, a very common instrument used for co-venturers in the upstream E&P business. There's a recording supplement that attaches to the Form JOA, or Joint Operating Agreement, that's promulgated by the AAPL, or the American Association of Petroleum Landmen. The Form 610 that's commonly used in the U.S. Contains a recording supplement that does have some limitations, as we'll cover in a couple of slides, but it is useful for the purposes that we'll talk about now, in that it is either in English, as it is, or if an instrument is not in English, it has to have a correct English translation accompanying it. The mailing address of the grantee and must be included. It has to be signed by the grantor, and it has to contain an acknowledgement. This is important, as we will see in a couple of slides. Simply filing something that isn't acknowledged properly will not always have the efficacy that you hope for it to have if push comes to shove. Could we advance to the next slide, please? Okay. An instrument that's properly recorded in the county is, as I mentioned earlier, if it hadn't cut out already, notice to the world or in Texas, or notice to all persons everywhere, that there is a superior claim out there, so that a lender or that a potential subsequent purchaser is on notice that you have either a piece of the property or some sort of claim to the proceeds derived from the property. And as the title is sort of, with apologies to Mark Knopfler and dire straits, it's why worry? Why not do these things and protect yourself? It's a fairly simple step. It's fairly inexpensive, and it's something that you can usually subcontract out to have someone, for example, head to the county clerk, or even in some cases mail with the appropriate fee attached, and have this recorded and have yourself protected. As the last bullet points out, a document that is not properly acknowledged is not entitled to be recorded. And you may find that in certain situations, the county clerk records it anyway, and that's fine, except that it doesn't provide constructive notice to bona fide purchasers for value. So just because it's been recorded, if it's been recorded in error because of not being properly acknowledged, the whole suite of protections is not available to you. So take pains to take the simple steps and get them correct. Can we go to the next slide, please? One of the most common or most frequent causes of title failure, and therefore, putting other parties on notice of what you have, is an insufficient description of the real property covered by the instrument. Now, in a joint operating agreement, typically the contract area is the area in question, and that contract area is evidenced often by an attachment, Exhibit A or B, or however you choose to put it into your JOA, of a list of leases. And so reference to this list of leases, if they have volume and page, proper recording information, is sufficient to communicate the information. But ultimately, one of the documents, either in the document or incorporated into the document by reference, has to have a sufficient description of the real property covered by either the transfer you're trying to protect or the priority of the secured claim that you're trying to protect. And the standard is really pretty simple. At least at first blanch, it must be that it must be sufficient that a person with reasonable knowledge of the area in question would be able to ascertain the boundaries of the real property that you're talking about. It doesn't have to be perfect. It doesn't have to be down to the meter or the centimeter or the exact hundredth of an acre. And here's where you get into the argument between precision and accuracy. I encourage you to, your surveyor, your abstractor, whatever you're using to get this right, get it as right as possible. But there is good case law that will say, there are some fairly outrageously loose descriptions that have been held to be legally sufficient because they're sufficient that a person would be able to understand, a person with knowledge of the area would be able to find it. I would urge you not to rely on the case law rewarding the more lax and loose descriptions, and try to get this as accurate as you can so that there shouldn't be any question. I'd like it to be drafted well enough that even a person who isn't familiar with the area, has very little professional capability, would still be able to know what you're talking about. That makes me most comfortable. Can we move to the next slide, please? All right, as we mentioned before, for this to be effective, the instrument has to be filed in the real property records of the county where the property is located, either for the transfer or where the secured interest lies. Often, a property will straddle several lines, be they county lines, state lines, the rocks, the petroleum systems that we're trying to develop oil and gas out of, don't pay a whole lot of attention to the arbitrary lines in the sand that humans have drawn to divide, say, Gonzales County from Lavaca County. So you'll often see that there's a tract that is in more than one place. It is sufficient to record your instrument in just one of the counties that's concerned. However, once again, I would urge you not to rely on what is really sufficient. There are some strangely drawn counties in Texas, and even if they're in other places where you've got your normal sort of right angle corners, It's not impossible. If you've ever been to Four Corners, New Mexico, for example, think of you can put your foot down in one spot and be in 4 states at the same time. So I do encourage you, even though it is sufficient to record in just one, I do take the belt and suspenders approach and recommend that you file in all of the counties concerned, not because you'd be wrong if you didn't, but because why go through the loss of money and time proving that you're right when it would have been easier just to put all parties on notice everywhere anyway. And the next slide, please. The collateral in question. Now, this differs from state to state. So I've taken language from Article 7B of the AAPL Form JOA that I mentioned. And the emphasis there is mine. Anything bolded and italicized is language that I've added there, the emphasis to. And once again, from state to state, this varies. But in Texas, oil and gas in the ground, before it's reduced to possession, before it's produced, is considered to be real property. And so all of the statute of frauds information would apply as normal. Once that's been reduced to personal property through being exercising dominion and control over it after production, it becomes personal property. So we'll talk about how the JOA and similar agreements provide lien rights to both types of property. Can we go to the next slide, please? This is where I talked about where the recording supplement that's included with the JOA, if it's left unchanged, it will create a lien in real property that's enforceable through judicial proceedings. It can be foreclosed. And the language from the JOA is included there in the middle. However, note the last bit of this slide. The JOA must be revised to name a trustee and include a grant of power of sale if that's required by the property code of the relevant state. It certainly is in Texas. So while it will allow you foreclosure, you still want the ability to have the trustee named and have the grant of power of sale. You need to slightly modify the recording supplement if in one of those jurisdictions to give yourself the complete protection available to you. Next slide, please. We move to personal property. If left unchanged, the JOA recording supplement will create a security interest that's enforceable under the Uniform Commercial Code. So if your state has adopted the model UCC without much change, you'll be comfortable with the language there in 7B. Each party grants to the others a security interest or a PMSI in any interest it now owns or hereafter acquires in the personal property. So it does refer to that as a lien and a security interest. So filing that will be sufficient for personal property. Can we come on to the next slide, please? Finally, if you get to the situation where your counterparty is in default, the remedies available to you or the consequences that party suffers are these. And this is important not just for the party that you're currently contracting with, but if, for example, your counterparty ends up selling assets or the entire entity changes hands, the things like the delivery of the notice of non-consent election are important because it means that the defaulting party, no matter who that party is, takes subject to the provisions of the JOA and is not available or not able to elect to participate in any subsequent operations that might be proposed by the operator or other parties, depending on the terms of the JOA. Also, the party who is in default can be sued, and this is important, at joint account expense to collect the amounts in default. And if you're feeling more like the party that might be in default, and you're asking yourself, wait a minute, did he just say that, let's say I'm a 35% interest owner, I'll be footing 35% of the bill to sue myself, then yes, that is what he said. So some comfort to those of you who are not in default and some extra alarm to those of you who are or think you might be, that the joint account expense is what's charged with the legal fees for collection of those fees. Obviously, the foreclosure rights and the rights of a secured party under the UCC at the top are important. And then finally, the last one, in the situation that operations continue under the agreement by the terms of the JOA, you can be required, or the defaulting party can be required to pay in advance their anticipated share of any items or expenses for which the operator would normally be entitled to reimbursement under the JOA itself. So you may, instead of paying as you go, have to pay all up front. Now that concludes my slides, everyone. That is admittedly a very high-level view, but just sort of a demonstration of the sorts of activities that you'll need to take and the sorts of consequences that are if you don't, that you face, and if you do, that the party that's in default or insolvent does. So if we can move to the next slide, we'll introduce Joe Tironi, who I think has got his audio working. He'll talk about lenders and lending facilities that we frequently encounter.
Hello, again, this is Joe Tironi. I'm sorry for the technical difficulties earlier. I'm going to discuss some issues related to reserve-based lending and the issues in light of the COVID-19 situation and the dropping oil prices and the upcoming borrowing base redetermination seasons. If I can get the slide to move forward. We got a bit of a lag. But as many of you know, in the upstream oil and gas sector, many of the companies fund a significant portion or at least some of their operations through reserve-based lending. These are asset-based loans where the amount available to borrow is based upon the value of specific identified oil and gas reserves, and that determines the borrowing base. Reserve-based lending loans are repaid from the proceeds of recovered oil and gas or other financings or other sources. They're usually not limited recourse. Lenders can foreclose on unsecured and unencumbered assets of the borrower and other oil and gas assets not included in the borrowing base, upon a default. Typically, they're revolving credit facilities to allow the borrower a lot of flexibility in funding their operations, and they tend to have maturity between 3 to 5 years. The borrowing base tends to be set up based on a number of considerations, and things to think about as you're going into this and to frame reserve-based lending in the current situation we're in. Oil and gas assets are by their nature depleting assets as they're being recovered. The prices for oil and gas, as we're all too aware, are volatile. And borrowers have very little control over the value of their reserves. The market's set with many factors. Individual borrowers have very little to do with it. And most importantly, I think, as we go into the redetermination season, is that lenders have significant discretion in determining the valuation of oil and gas assets for determinations of the borrowing base. Okay, advancing to the next slide. Now, the borrowing base, just very quickly, it's set up through a process of reserve reports that the borrower prepares, usually using an independent petroleum engineer or on their own. The lenders, or usually a independent petroleum engineer hired by the agent, reviews these reports, and they determine a borrowing base off of a number of factors, including historical performance and also their view of the market going forward. They look at the locations of the oil and gas assets, the actual production history, obviously the market price, current market price and their views and going forward, an estimate of the O&M costs related to those assets, capital expenditures required in order to produce the oil and gas revenues, and other risks relating to operating, regulatory, legal issues, and diversity of the assets. Moving on to the next slide. The borrowing base redeterminations occur usually twice a year. There can be other reasons why they would occur. I think usually under most agreements, 1 or 2 times a year, the lender or the borrower can ask for a redetermination, but usually it's a spring and a fall redetermination season. I think if you look at the where crude oil prices have gone, looking into the 2020 redetermination seasons, it's good to look back to the 2015-2016 redetermination seasons. There we saw a significant drop in crude oil pricing, and really in general, well, you can't make these generalities apply to every lender in the sector, but in general, in 2015, we saw an area where it was a significant price drop. Banks tended to be overexposed to the oil and gas sector, and there was fairly tight liquidity for the borrowers in this area. And in general, in 2015, the lenders seemed to be fairly accommodating with respect to borrowing base reductions, waivers, and other accommodations. They did not push many borrowers into defaults if they could avoid it, or into potential bankruptcies, although many did occur. But what they did do is they, in connection with these waivers and being more forgiving to the borrowers, they added a number of tightening on covenants, and in particular, anti-hoarding provisions came into play to a large extent. And these were provisions to stop borrowers from, just prior to a redetermination, pulling down all of their available borrowing capacity from a reserve-based loan in order to get as much cash on hand, perhaps give them more leverage with the lender in connection with the redetermination season and any waivers that would be necessary, or to have cash on hand in case that their situation would go into insolvency or bankruptcy. And the anti-hoarding provisions essentially limit when drawdowns can occur, essentially making a mandatory prepay event if excess cash exceeds a certain amount, and prevents draws if they have the borrower has cash available at certain levels. Moving forward. Now, really looking into this 2020 borrowing base seasons, I think that there are a number of corollaries to 2015 and 16. The one situation that I think is going to be helpful, I think there's more liquidity in the sector right now than there was in 2015 and 16. I think that'll be helpful for borrowers, but obviously the tremendous drop in the prices on the market are going to lead to some very tough discussions. I think some of the considerations for the borrowers and the lenders in going into the redetermination seasons are going to be, to the extent they've been able to move their reserves that the borrowing base are based upon from non-producing to producing assets, that will be a factor in their favor. To the extent that borrowers are able to make required prepayments if their borrowing base is reduced, that will help them in their negotiations. And a lot of it has to do with whether they have alternative sources of capital. Another ability to cure a deficiency in their borrowing base is through the allocation of additional oil and gas assets. And if that's a possibility, they can secure those as well. Ultimately, it comes down to a decision from the borrower. Is it better to go into a bankruptcy proceeding, or is it better to accede to the demands of their reserve-based lenders? On the lender side, they have significant discretion, whether it's to grant waivers or even in the determination of the borrowing base. This discretion is not surprisingly, wielded subjectively to a certain extent, dealing in their ultimately in their confidence in the borrower's ability to meet their obligations going forward. The tended to be looking at a number of different tools in their basket. In addition to reducing the borrowing base, they can also add requirements for new collateral, add further prepayment obligations, increase fees, and tighten other financial covenants. The lenders have tended to be more flexible where the borrowers are have large and diversified operations. To the extent that they're hedged, that's helpful. And I know Paul Turner will talk about this a little bit going forward. And to the extent they have other sources of capital, the lenders tend to be a little bit more forgiving. And again, it comes down to a little bit of a game of chicken. Ultimately, is the bankruptcy of the borrower better for the lender than giving waivers or other accommodations to them? So as the season progresses, whether it's this spring or this fall, we're going to see a lot of these decisions, and some of them are going to tilt the borrowers towards bankruptcy, and others, they might be able to hold on, and maybe it'll be in the fall, maybe it'll be next spring. Some of these issues are going to come home to roost. I'm sorry.
Let me jump in real quickly, as you mentioned, because we're on this slide, and we have the bullet about the hedging. In looking at the participants, I see that there are some folks from sort of large companies that do offer various hedging products to producers, and oftentimes with regard to an upstream producer that has a reserve-based lending facility in place with the banks, the hedging is often done through a secured hedging facility, which is essentially based on the same collateral quite usually, and would be, the secured hedge provider would be paid out on a pari passu basis on the same level as the lenders. And when you're looking at those kind of secured hedging facilities, however, it's important to recognize that there are issues different from just a pure hedging product or providing derivatives, engaging in derivative transactions with a counterparty, and actually being part of a syndicate like this where you're part of a lending and secured hedging facility, in particular, because as we talk about a little bit later, with regard to safe harbor contracts like the swaps, where you have a single pool of collateral that is to secure both the loans and the hedges, you have significant risk that the bankruptcy court will not let you foreclose on collateral, will not let you sort of basically exercise certain of your safe harbor rights with respect to hedges because the collateral is a single pool and the lenders don't have the same rights. So there are timing issues and risks associated with the secured hedging that would be less prevalent at the for typical hedging transactions.
Yeah, thank you. That's a very good point. And with that, I will turn this actually over to Paul for the next slide. And thank you very much.
Sure, thanks, Joe. So up to now, we've been talking a good bit about some of the issues arising. And can we move to the next slide, please? I will take control. Let's see if this works. Yep. Okay. Up to now, we've been talking a good bit about some of the issues that will arise for companies prior to bankruptcy and the new redetermination periods, and/or some of the trends that may lead to potential bankruptcy. I think before we get to the actual hardcore bankruptcy stuff, it may be useful just to sort of talk a little bit about, okay, we know that when a bankruptcy hits, there's going to be a lot of a good bit of chaos and confusion, and there's a lot of stuff that needs to be done. And the more you can get done, if either as a debtor, frankly, or as a counterparty to someone who might become a debtor, the more time you have to prepare, the better. And so, I'm not going to go through all of these, but we thought it useful to sort of just to sort of think about some of the signs that often arise prior to someone's filing for bankruptcy. If you hear about a counterparty that has significant principal and interest payments coming due, or a bond that's becoming fully due, or if you hear in the trade press that someone is expected not to be able to make that bond payment, those are things to just keep in mind. Late and restated financials. Those are sort of market issues that you might hear in the marketplace. Obviously, on the right side of the slide are things that are frankly a bit more tangible. But if you hear that a counterparty is downgraded, that's a risk, particularly if the counterparty is downgraded beyond below investment grade. If if you see that there are vendors who are sort of filing liens, or if a counterparty is delisted from a stock exchange, those are fairly concrete issues that give you an indication that there are troubles from a financial standpoint afoot. Now, as we get closer, there are some issues that are not only yellow flags, if you will, that sort of may give you pause, but there are some real red flags that bankruptcy is a real possibility, and it may not be far off. To the extent there are significant shakeups or changes in the senior management and senior leadership, particularly if you have several of those types of folks being replaced. If you hear obviously that a company is retaining a restructuring officer, particularly if that person is from one of the restructuring companies, that's a pretty good indication that there certainly is some consideration of a bankruptcy. Obviously, if they sort of hire insolvency professionals, again, pretty good sign that there's a very good chance that that company could file for bankruptcy. You want to sort of keep your ears open and eyes open as trends develop, just so you're not caught behind. Now, before the bankruptcy, Joe talked a little bit about some of the lender facilities and lender issues. I'm not going to spend too much time on this, but before bankruptcy, we do often see banks and lenders trying to work things out in some manner or fashion. And that often takes sort of a two-step process where you have sort of what we call pre-negotiation letters, and that sort of sets up basically the framework and terms for discussions, so that both sides can engage fully in trying to resolve it pre-bankruptcy and work it out, so that basically those discussions don't provide waivers or an agreement to forbear, that any sort of modifications will need to be done in a signed writing, and that any discussions, as settlement discussions, wouldn't be admissible if there's a future bankruptcy and report pursuit. And then if successful, you would have an actual forbearance agreement, which would hopefully avoid, in many instances, the bankruptcy. And we saw a lot of this in 2015, where, as Joe mentioned, you had a tightening up of the covenants. You had acknowledgments by the borrower as to what the defaults are, and sort of a reworking of what those terms might be, including increased fees, for example, and potential future waivers of defenses and counterclaims. So, that is a step that oftentimes you'll see before bankruptcy, but unfortunately, that doesn't always work. Next slide. With respect to someone who may have contracts with the potential debtor, it's important that even before bankruptcy, you start taking some actions to best protect yourself. Because, as I mentioned earlier, if someone does file for bankruptcy, it gets pretty chaotic pretty quickly. So, keep your ear to the ground and, sort of keep your eyes open to try and to sort of see the kind of warning signs we saw before. From a credit group perspective, or make sure that you're monitoring both your exposure and the collateral that you hold or could be holding closely. If you're under collateralized and you have the right to call for collateral, you should definitely do that. It's important also to monitor payments and collect them when they're due from a potential defenses to future bankruptcy litigation. And if you have a lot of different types of contracts and different multiple contracts with a counterparty you have a real fear of going into bankruptcy, it may make sense for you to sort of start pulling those contracts so you have a good sense of what you may need to do if they do file for bankruptcy. Let's move. The last point too is it's always better when someone goes into bankruptcy, if that someone isn't you, that you have money in your pocket owing to them rather than them having money owing to you. So it's always better to be out of the money to the extent you can be when someone files. Next slide. Okay, but that always, as I said, that doesn't always work. So, oh no, my counterparty filed. Next slide. Okay, so very soon, Kevin will be sort of talking more broadly about the types of bankruptcy issues, bankruptcy process, et cetera. But from a counterparty contract standpoint, I think it's important that when a counterparty files, you really do need to gather information quickly. You need to have a good sense of, do I have deliveries on the way? What payments are owed and owing? I need to, if I have originals of letters of credit, guarantees, I need to start pulling those from the vault, figuring out your collateral, and presumably on a daily basis, if you have forward contracts and hedges, you're valuing them on a daily basis, getting a sense from just your modeling sort of what those net values may be, and then there'll be first day motions that may impact you significantly as well, and Kevin will talk about that. So with that, I think next slide, we'll turn it over to Kevin.
Review of Chapter 11. There's probably just too much to present at this point to give you a full flavor of what's going on. So I'm just going to give you a little outline, and again, I'd be happy to provide any specifics with you offline. The first thing is Chapter 11. As Paul indicated, it's chaotic right away, and this is particularly true in Chapter 11 in a reorganization. The purpose of the 11 is to restructure the debt and get rid of bad contracts with an idea that the debtor will reorganize and go forward. I'm trying to get forward here. Okay, I'm sorry. Here's a list on this slide of various parties that you might see in a Chapter 11 case. You have the debtor in possession, who will be hiring professionals, including their attorneys and financial advisors, and their retention is going to be approved by the court. You're going to have lenders. They could be pre-petition secured lenders or DIP lenders. A category would be the Official Committee of Unsecured Creditors. The committee is formed by the U.S. trustee, and it's composed of representative creditors. The committee and the members of the committee are fiduciaries for all the unsecured creditors. And again, like the debtors, the committee will be hiring its own professionals and being retained through the court. The U.S. trustee is the governmental entity which basically oversees the entire process. You can also have unofficial or ad hoc committees. They can be players in the Chapter 11. Common unofficial committees would be bondholders or statutory lien holders, for example. And then finally, you're going to be seeing contract parties and creditors. The automatic stay is probably one of the most important things that you need to take away at this juncture. And it's a huge protection available to the debtor. It's triggered immediately on the filing of the bankruptcy, and it stops acts and proceedings against the debtor and its property. It is a nationwide, maybe even worldwide injunction, and it bars almost all actions against the debtor and its property, including exercising remedies concerning collateral, enforcing pre-petition judgments, litigation, collection efforts, and acts to create or perfect and enforce liens. And it applies to all creditors, whether you're secured or unsecured. By its very nature, it's temporary, and it can be lifted by the court under certain circumstances, as well as some exceptions that are found in the bankruptcy code. Again, relief can be granted by motion, but courts are usually reluctant to grant relief early in a bankruptcy case. They want to get the debtor ability to get their feet on the ground. But there are reasons why creditors might want to move early for relief, including getting adequate protection. That's because some courts held that the rights to receive adequate protection aren't triggered until the creditor actually files that motion for, or the creditor files a motion for the stay. Courts really have broad discretion in determining cause for granting relief, and it depends on the facts of each case. A takeaway here, it's important to remember that a willful violation of the stay can result in damages, including attorney's fees and punitive damages. So a warning. I'm sorry?
Willful violation can lead to the potential for treble damages.
And so that's more reason to be very careful with, and when in doubt, seek relief from the automatic stay. Here's a kind of a little overview of what you're going to see in a Chapter 7. And at the outset, as you can see at the bottom of the slide, is the petitions filed with the bankruptcy court. At that point in time, the bankruptcy estate is established. Then with that, the debtor often files what are called first day motions to address administrative or operational issues. They can be entered on an interim or a final basis. The first day is usually within a day or two from the filing, and some of the procedural motions would be administration of the joint administration of the estate, or a motion to extend time to file schedules. More operational motions would include paying certain pre-petition claims. They would include paying employees, paying critical vendors, paying lien holders like shippers, warehousemen, and mechanics, and also paying taxes as well as utilities. But probably one of the most focal points of the first day is the cash collateral and the DIP financing motion. The debtor needs the financing and an ability to use the cash collateral to fund its operations and costs in the bankruptcy case. Without access to this cash, the debtor can't fund necessary post-petition expenses like payroll or utilities, rent, and paying professionals. This financing motion would be entered on an interim basis, and then after the committee's formed, within a week or so, there would be second day hearings, which would revisit some of these first day motions, including the DIP financing. Between the formation of the committee and the second day, the debtor is going to be analyzing the case and working with the committee, and sometimes even battling with the committee on a go-forward plan. And again, at this point in time, the debtor is analyzing its business and deciding what contracts the leases can be rejected. And again, there's probably two main paths that you're going to see. One is to file a plan of reorganization, and the other is to sell substantially all of its assets. Let me jump to, on this slide, proofs of claim in the claim process. A proof of claim is the equivalent of a complaint that you would see in a civil action. Again, a motion would be filed to set a bar date and filing procedures for the creditor to follow. Claims can be a variety of shapes and forms: secured, priority, administrative, and general unsecured. The code provides for in order of paying these claims, an administrative cost for running the bankruptcy would typically be paid first. Next, you would have secured claims are paid. And if there's still money left over, unsecured creditors would be paid on a pro rata basis. Equity would be last in line to get paid. And that would be only if the everyone in front of them is paid fully. Okay, another concept that I think is important for you to be aware of is just the executory contracts and in bankruptcy. And I know we've talked about it earlier in this presentation. The idea here is that bad contracts can be gotten rid of by the debtor. The code has no specific definition of what an executory contract it is, but as a general rule, it's one where performance remains due to some extent on both sides. For example, an ongoing lease or a supply agreement. Section 365 provides the debtor with flexibility so they can either assume the contract or assign it to a third party or reject it. By assuming or assigning the contract, the debtor binds itself or the assignee and the counterparty to perform under the contract's original terms. With an assumption, the debtor has to cure or pay what was owed under the contract, even if it was pre-petition. So that's an important aspect. The contracts can be rejected, and that would relieve all the parties of any further obligation. The damages that the counterparty would have on a rejected contract would be treated as a pre-petition breach and be an unsecured claim. So the decision to either assume, assign, or reject the contract requires court approval, but courts are usually deferential to the debtor's business judgment. But remember that until the contract is assumed or rejected, both the debtor and the non-debtor party have to perform under the contract's terms. A 363 sale often has a breakup fee that encourages a stalking horse bidder to participate, and it gets reimbursed if it loses it to another bidder. And then, in any event, the debtor will, or its financial advisor will be marketing the assets. The court needs to approve the bid procedures, including the breakup fee and eventually the sale agreement. You'll see on the chart, one of the steps is that an auction takes place and a winning bidder is selected. Not all the times is it real easy to determine who the winning bidder is because you might be comparing apples to oranges. Then finally, you have the sale hearing. Just a point of note, the 363 sale is a great opportunity to pick up assets on the cheap. Another major benefit is that the assets would be sold free and clear of liens to the extent that that would be allowed under non-bankruptcy law. Another alternative would be the plan of reorganization, and the plan will specify how the debtor will continue to operate or liquidate and how the claims will be paid. It generally categorizes claims into classes, will describe the treatment of each class, and then identify how the debtor will implement those terms. Again, the disclosure statement is court approved. That, along with the plan, goes out to the creditors for voting. So at the end of the day, the court and creditors are going to be approving the plan before it becomes effective. And a final concept that I wanted to raise today is the critical vendor orders. They're usually on the first day. You'll see that, but they can be filed anytime in the case. With that, the debtor is seeking authority to pay pre-petition vendors that they think are crucial and non-replaceable. There's a real high burden on the debtor to show that these critical vendors should be paid, outside of the normal Chapter 11 priority scheme. And only the most vital vendors are paid, and only where there's no substitute or alternatives are available to the debtor. And critical vendors motions they hinge on conditioning the vendor to agreeing to favorable terms. And if the vendor breaches those terms, payment could be disgorged by a motion. So once you enter into the order for a critical vendor and accept the payment, you have to abide by those terms or you're going to lose all your money on that. So with that, I think I'm going to turn it back over to Paul to wrap up.
All right. And Joe, do I understand correctly that someone has a question?
Yes, and I think this is probably for you, Paul and Kevin. This is coming from the participants. How aggressive can we be about protecting our position when we believe that a contractual counterparty is headed to insolvency or bankruptcy, but their defaults may or may not have risen to the level that triggers a termination right? What can we do as we watch the ship sink? Are there any advantages, disadvantages to terminating a contract just prior to the filing of bankruptcy by a counterparty?
Oh, okay, so great question. I will, Kevin, if you don't mind, let me sort of jump in a bit, because based on some of the language being used, I'm frankly assuming that the question in large part is asking about some of our safe harbor contracts, our forward physical contracts and our hedges and that sort of thing. So before answering the question, let me sort of provide and this is material I would have otherwise covered on the next slide or two, leave a quick background. Kevin talked a good deal about the fact that with the automatic stay and that goes into place immediately, forecloses or precludes folks with executory contracts from exercising rights of termination, foreclosure on collateral, demanding collateral, et cetera, and set off various other things. And that is, of course, one of the key weapons in the debtor's toolbox, if you will, or quill. Interestingly, of course, for those of us in the energy industry, as I think we all know, when it comes to a lot of our contracts, forward physical contracts in which you're selling a physical commodity forward with deliveries of more than a couple days ahead, and with respect to derivatives / hedges, swaps, and also master netting agreements that provide for certain set-off and netting rights across those types of instruments. You have exceptions in the bankruptcy code to the automatic stay that, in fact, allow you to exercise some of your termination, acceleration, liquidation, and foreclosure rights with respect to those contracts, which is, of course, very, very useful if those contracts qualify as a safe harbor contract. So, so I thought that in answering the question, I think it's important to understand that quick background. The question as to, what if there are some types of defaults or quasi defaults or technical defaults that don't quite arise to a level that allows termination. And in those instances, I think it seems to me that if they don't rise to a full-fledged event of default for which you can give a notice and a cure period, at the very least, in many of those instances, you may want to consider the extent to which those kind of technical defaults or defaults actually give you some form of insecurity as to the performance of the other party, for which you may want to demand a form of adequate assurance. Of course, for that may not be practical on most of the for a lot of the derivatives and ISDA side, because under those you typically waive the right to call for adequate assurances, but you're also typically fully collateralized under the credit support agreement. But for those on the physical side, you may not have quite the same level of right to collateral that you might have on a credit support annex, and therefore might want to ask for some form of adequate assurance, which, if the potential debtor doesn't meet, would arise to a repudiation of the agreement or an event of default, which would allow you to exercise your termination rights. So that's one strategy. As a practical matter, oftentimes what you get back from them is we assure you that we will perform, and that's sufficient adequate assurance. So you do still have a bit of a dispute, but that's one way to approach it. As to the exercise of a termination right or event based on an event of default prior to a bankruptcy versus based on the bankruptcy, if we're talking about those types of contracts that we are clear on the fact that they are safe harbor contracts, if you're talking about several days, it doesn't make much of a difference at all. Unless you are afraid that they might try and make you a critical vendor. Because you're not going to get, because of the safe harbors, you have the right to exercise your rights even after the bankruptcy. And if you do so promptly, those are effective. So, the matter of a few days isn't going to make a difference. If it's, going to be a week or a month until you're afraid they may go bankrupt, then there could be substantial cash differences in the potential debtor position that could be helpful to terminate early. I think that addressed most of the points in the question. And if there were more, I'm afraid I'm getting any others.
No,
Well,
thank you,
Paul,
Paul. I think that's very good. And to the extent that anyone has anything else to add, please type in the Q&A any section for any follow-up.
If you want to add to my answer, that's fine too.
Yeah, I just wanted to just say, a lot of times credit terms or things will change right at the eve of the bankruptcy. And sometimes you're going to be subject potentially to a preference action under the bankruptcy code, a payment that is due on account within 90 days as the payment is received of the bankruptcy. And as Paul pointed out earlier, it's better to have the money in hand. So if you're changing your credit terms or doing something aggressively, you're running the risk of having a preference action brought against you. But to sit idly might not be the best scenario either. So just be aware that,
I think too, we'll probably be talking about preference and fraudulent conveyance actions more in our next webinar, which will be held next week, next Wednesday. I will avoid saying same bat channel, same bat time. But with regard, one thing I will say about preferences and fraudulent conveyances, again, with respect to safe harbor contracts, there are some beautiful exemptions and protections that we have in our industry with respect to those, where you have a defense with respect to safe harbor contracts from a preference action, and you have a defense from a constructive fraudulent conveyance action as well. Now, if you engage in actual fraud in connection with the fraudulent conveyance, then the defense doesn't apply. But we'll talk about those. I think, Kevin, you'll be on and I'll be on next week. Well, I think actually most of the things on this slide we have covered already. And, here I list the types of contracts that do qualify. You have the commodity and forward contracts. This is not a complete list, but you have the commodity and forward contracts, the swap agreements, master netting agreements, and I list a number of the types of activity that for most contracts, executory contracts would be subject to the automatic stay, but here are not. So when someone does, and this is sort of the flip side to the earlier slide I had where if your counterparty is potentially close to or declining into bankruptcy, you want to make sure you assess your contracts, assess your deliveries en route as a preparatory matter. Here, once they file, you really want to sort of make sure you have these types of items well understood and well in hand, because one of the big disputes that often, next page, that do arise with the debtor, particularly with respect to swaps and forward contracts. So, as I say, one of the biggest kind of disputes you have with respect to these is one of valuation and whether you followed the contractual terms and methodologies for coming up with the early termination value or the termination value of your positions under the master agreements. You know, if you have a counterparty with whom you have done a lot of business over the years, you might have some 1992 instance. You might have some 2002 instance. You may have some NASBs. You may have BEIs. Heaven forbid, you may even have some Western Systems Power Pool agreements, WSPPAs. And each of those, and you may have various bespoke contracts. Each of those have different contractual language with respect to the methodology for valuing the termination amounts of the specific positions. And you need to really be careful in how you follow them. In each of those, you often will have some discretion as a non-defaulting party, but you want to make sure, A, that you do it consistent with those methodologies, do it in a reasonable manner, and also that you document pretty well what you've done, how you went about it. So for example, if creditors are getting positions, you sure don't want them on the line saying, hey, so-and-so just filed for bankruptcy and I'm looking for some replacement position quotes. That would not be a good thing to do. You want to sort of make sure you meet with the folks who are going to be gathering the information, give them a clear idea of what they should and shouldn't be doing, and document and retain what you've done and how you've done it. Also, when you're making the decision to terminate a safe harbor contract, you need to make that decision pretty quickly, because the longer you wait, the greater the risk that a court will find that it was not effective. All right. As I mentioned, we didn't get too much into the safe harbor side of things, so that we sort of did a bit of an intro and a bit of a refresher. Next week, where we are focusing more on the bankruptcy litigation issues and trends, we'll be focused more on various types of litigation issues, including, from my perspective, some of the safe harbor issues, set off, valuation, et cetera, preference. And so hopefully you'll be able to join us for that. It really, we're glad we had the opportunity to reach out to you and talk to you, and hope everyone stays safe and socially distant. Joe, do you want to wrap it up?
Yes, thank you all for joining, and we apologize for the technical difficulties, and I reiterate on behalf of everyone at Womble Bond Dickinson, Paul's wishes that everyone stay healthy, safe, and socially distant. Thank you very much.